I'm back. I'm Stephen Gold,
I'm
the author of The Return of Breaking
Law,
Law,
of which I have a copy.
for which you didn't pay.
May I quote you on that?
You probably know as much about flight delay claims as I know about how itchy a judge's head can get if they keep their wig on for too long in hot weather. If you've put in a claim to an airline that kept you hanging around for too long, there's a good chance it was rejected because the airline maintained that the delay was due to what legislation calls an extraordinary circumstance. That's what BA City Flyer said to Mr. and Mrs. Lipton when their flight from Milan to London City Airport was actually cancelled. And why? Because 1 hour before the flight was due to depart, the pilot reported in sick. BA had no replacement pilot available. The Liptons were rebooked into a replacement flight, which meant delay worth £250 in compensation. The Supreme Court, in a major ruling that could affect you, has just had to decide whether that sickness was an extraordinary circumstance which let BA off the hook. What do you think, folks?
Never.
Of course it was. Or perhaps it wasn't.
Or maybe it was.
Cue drum roll. The Supreme Court decided it was not an extraordinary circumstance. The purpose of the relevant legislation was to ensure a high level of protection for passengers. The crucial question was whether what happened was inherent in the airline's normal activity. If it was inherent, the airline was stuffed. And how the Supreme Court, a pilot's absence from work due to illness was part of BA's activity as an air carrier and could not be categorised as extraordinary. Staff illness was commonplace for any business, in the same way as the wear and tear of a plane's physical components was considered an inherent part of the airline's activity and so could not shield them from a delay claim, so too was managing illness of staff. The decision means that if your flight was delayed because of airline staff illness and you've been turned down for compensation by the airline, go for it again. And if you have to make a county court small claim, it may not be too late. You've got 6 years from when the delay occurred. One other point for the legal beagles among you. Brexit meant that the regulations governing flight delays had to be redrawn, and there were some differences between the old regulations and the new regulations. If the differences would affect the result of a case, they didn't in the Lipton's case, which set of regulations should be applied? An important and wider point which could affect not just flight delay claims but other regurgitated Brexit legislation. The Supreme Court said that the law to be applied was the law in force when the right to make a claim arose and not when the case was heard or at any other time. You may reckon this is pretty obvious, but if you read the judgments of the Supreme Court, you will realise it isn't. Come to think of it, you may fall asleep before realisation. Sweet dreams. I say. What is the definition of an expert? Somebody who tells you what you already knew in language you can't understand. I love that. But an expert you may need in your case, sometimes even in a county court small claim, if, say, the issue central to the success of your claim or defence is technical and not related to matters within the knowledge of everyone, like the number of days in the week or the number of times the 3 lines have lost in a final.
Ouch.
2 major civil court rulings have been made on expert evidence in the last couple of weeks. First, the Court of Appeal dealt with the use of single joint experts, which I know does sound like a contradiction in terms. A single joint expert is just one person.
No.
Just one person who's asked by all the parties in the case to give expert evidence on some issue, usually in the form of a written report.
And if you don't like what's in the report?
Well, you could always try and get the court to agree to you relying on a second expert instructed just by you, who hopefully will be more favourable to you. But unless you can show the joint expert has been talking out of the back of their head, the court might well refuse to allow that. So you'll be sunk. And that's why a single joint expert on a crucial issue is so unpopular, particularly in more substantial cases, even though they may, more likely will, be charging an arm and a leg or two for their services. Now, in the recent case before the Court of Appeal, it was acknowledged that in the bigger cases, like multi-track claims, usually involving more than £25,000, and like the one in question, the practice tended to be no single joint expert, but for each party to have their own expert. But that didn't mean there was no scope for the opposite to be ordered. It might be proportionate to have just the one expert, although proportionality was not the only consideration. In the particular case, the Court of Appeal affirmed a lower court's decision to restrict 3 defendants to using a single joint expert against their wishes. As it happens, there was no conflict of interest between the 3 defendants in this case, but even if a conflict had existed, a single joint expert could still have been justified, said the appeal court. And the fact that the expert might be giving an opinion on controversial matters didn't mean that their use was inappropriate. The second recent case in the High Court concerned the situation where each side has their own expert, not one of the single blokes, and before the case comes on for trial, those experts have to confer to draw up a statement about the points on which they're agreed, the points on which they're not agreed, and the reasons for that disagreement. This statement is commonplace in the more substantial or complex claims. And depending on what the opposing experts say at that stage of the proceedings, a statement could make or break a claim or a defence. There are pretty strict rules about the input the lawyers on each side can exercise in what their experts put into the statement. The lawyers can certainly assist their experts in identifying the issues which the statement should address. What they must not do is to become involved in the negotiating or drafting of what goes into a statement. And they should only invite their expert to consider amending their contribution to a statement in exceptional cases. In the case before the court, alas, London solicitors for one party over-poked their noses into what their expert had stated. When it came to the third draft of the statement, those solicitors made extensive revisions and deletions with comments and went over the top in doing so. They eventually accepted that they had gone too far, although the court accepted that this hadn't been deliberate. They hadn't understood the relevant rules. They must now use a replacement expert and bear the legal costs triggered by their conduct. When a marriage or civil partnership breaks down and the court is asked to decide how the couple's assets should be divided between them, it will usually look to see if a 50-50 split would be fair. That's the sharing principle, and it will generally leave out of account the assets that one party owned before the marriage or partnership and inheritances they've received. They won't be split. They are regarded as non-matrimonial assets to be wholly retained by their owner. But every now and then, assets like that will be ordered to be shared. This they call matrimonialisation. In a High Court case involving megabucks, the judge declared, "I'm going to matrimonialise," as one does. What had happened is that when the husband and wife were harmoniously living together, the husband had wanted to reduce his liability for inheritance tax on his death. He got expert advice about how to go about that. And so, as he was advised to do for reasons for which I will not bore you, he transferred to the wife a cool £77 million, which had belonged to him before the marriage, so that she could pay the money into some trust funds. But when the marriage broke down, she still hadn't done that. The money was still in her name. The judge took the view that although the £77 million had been a non-matrimonial asset, it should be treated as a matrimonial asset and be shared with the wife because it was now in her name. But the Court of Appeal has recently ruled that the judge had been wrong to do that. He shouldn't have been swayed by the fact that the money was in the wife's name. He should have concentrated on the source of the money, the husband.
So, what did the Court of Appeal do?
Well, the wife had been awarded £45 million, which wrongly reflected a share in that £77 million. The Court of Appeal ruled that it should have been £25 million, but that could yet be adjusted in the light of an assessment that has yet to be undertaken of what the wife's needs are. And the appeal court stated that matrimonialisation should be applied narrowly. What was fair mattered, and although the source of the 77 million had been decisive in this case, its importance might diminish over time. Incidentally, the 50-50 split won't apply where the needs of one of the parties dictates that they must have more, particularly where, say, one of the parties assumes responsibility for the care of children. And the matrimonial home is likely to be dealt with in a different way to other assets. This is the name of the Court of Appeal case.